Welcome to the Deep Dive. So if you're listening, chances are you care a lot about things like rights, justice, liberty. I mean, they're the bedrock of a free society, right?
Absolutely. Foundational concepts.
But here's this weird thing, this paradox in our time.
Yeah.
We talk about these ideas constantly, but the actual philosophy underneath them, natural law, it's almost forgotten.
Yeah, it's often overlooked. Even in law schools or political science today, it can feel like a historical curiosity rather than a living foundation.
Right, like we've somehow misplaced the blueprints for the house we're living in.
That's a great way to put it. And that's really our mission today, isn't it? To kind of dust off those blueprints. We want to dig into the core principles of natural law, viewing it as this universal moral order, something rooted not just in tradition, but in human nature itself, and really crucially, in human reason.
Reason being the key.
Exactly. We want to understand how this really old and persistent tradition established our fundamental rights, life, liberty, property. The idea is that governments don't create these rights. They're supposed to recognize them.
So it's a limit on government power from the start.
Precisely. It serves as a vital safeguard against just arbitrary rule, against the government just deciding things on a whim. And also against this modern drift towards moral relativism, this idea that there's no real right or wrong. Natural law insists there is a standard, something higher than whatever laws people happen to pass.
And we should probably stress right off the bat, this isn't some dusty, unchanging dogma locked into one specific viewpoint, is it?
Oh, not at all. That's a common misconception. It's really a developing tradition. It spans thousands of years, crosses cultures, different religious perspectives.
So who are we talking about?
Well, you've got the ancient Greeks, obviously.
Huh.
Plato, Aristotle, they were already connecting virtue to the structure of society. Then the Stoics, who really emphasized living according to nature, meaning reason.
And the Romans.
Yeah. Cicero. Definitely Cicero. He was huge in formalizing these ideas in a legal context. But then it keeps going, right? You see it woven into Jewish philosophy, like Maimonides, later Mendelssohn, blending reason and revelation. Mm-hmm. And then, of course, major figures in Christian thought. Thomas Aquinas is central. We'll definitely get into him. But also Protestant thinkers like Grotius, Vattel. These guys were foundational for international law, all drawing on this natural law bedrock.
Wow, so it really is this continuous global conversation.
It is, about justice, about what makes a society good.
And the common thread, the thing linking Plato to Vattel, is this idea that, that people can figure out some basic moral truths.
That's the core conviction, yeah. That everyone, just by virtue of being human and having reason, can grasp fundamental distinctions between good and evil, right and wrong.
Like the golden rule.
The golden rule is the classic example. Do unto others. Yeah. You find versions of that everywhere in all sorts of ethical systems. It's accessible through reason. Yeah. You don't need a special revelation to understand why treating others with basic fairness is, reasonable. And that very accessibility, that grounding in shared human reason is why this tradition has been so resilient, why it keeps popping up even when political fashions change.
Okay, so it's broad, it's ancient, it's adaptable. But you mentioned Aquinas. If we want to understand the structure of natural law, he seems unavoidable.
Absolutely indispensable. Thomas Aquinas in the 13th century, he didn't invent it, but he gave it this incredibly systematic, comprehensive form. His Summa Theologiae, it's like the architectural diagram for how reason, morality, justice, and government all fit together.
He synthesized everything that came before.
He did, especially Aristotle.
Yeah.
He brought Aristotelian philosophy into conversation with Christian theology and legal thought in a way no one had before. But it wasn't just about citing authorities. There's this great story.
Oh, yeah.
A student supposedly asked him how to win philosophical arguments. Should they just quote respected texts? Aquinas basically said, look, if you're arguing with people who don't accept your authorities, you have to use natural reason. You have to trace the argument back to its roots in logic and shared understanding.
So appeal to reason itself.
Exactly. Even within theology, he insisted on finding the reasons behind things, not just accepting them on faith alone. That conviction that these moral truths are knowable through reason, that they're defensible logically, that's the engine driving this whole philosophy.
Okay, that sets the stage perfectly. Let's dive into section 1 then. Really nailing down what natural law means by focusing on this idea of right reason.
Sounds good, because that phrase itself, natural law, can definitely trip people up.
Right. Natural makes you think of, the jungle.
Biology.
instinct.
And that confusion isn't accidental. It actually goes back to a major fight in ancient Greece.
Between Plato and...
The sophists. They were these traveling teachers, very skilled in rhetoric, and their basic take was that laws and social rules, no Mars, were just made up. Conventions based on nothing deeper than who had the power to enforce them.
Okay.
So for them, natural physis meant the raw reality underneath the conventions. And what was that reality? The strong dominate the weak. Might makes right. That's what's natural for the sophists.
That sounds pretty bleak and potentially tyrannical.
Extremely. If there's no objective standard for justice, just power, then anything goes if you can get away with it. So Plato and Aristotle consciously took back the word natural.
How do they redefine it?
For them, and for the whole natural law tradition that follows, natural means specifically human. And what's distinctively human?
Reason.
Reason. Our capacity to think, to understand, to choose based on understanding. That's what separates us from animals acting purely on instinct or appetite. So natural refers to our rational nature.
Okay, so natural equals human reason. What about the law part? If it's not written down, codes passed by a legislator.
Right. The law part isn't about statutes primarily. It refers to that which is right for us as rational beings. What reason identifies as good and just, not just what's useful or efficient or popular, but what aligns with our rational nature and leads to our genuine flourishing.
And Aquinas tied this directly to practical reason, didn't he? The sort of reasoning we use to decide how to act.
Exactly. He laid out these fundamental, you could almost say self-evident principles of practical reason that guide all truly human action.
Okay, what's the most basic one?
The absolute bedrock is good is to be done and pursued, and evil is to be avoided.
Simple enough. But what counts as good and evil here?
At this foundational level, good just means that which is reasonable, that which provides a reason for action. And evil means that which is unreasonable, acting against reason. If we're defining ourselves by reason, then acting reasonably is acting well, and acting unreasonably is acting badly.
Okay, so pursue the reasonable, avoid the unreasonable. What comes next?
Then you have secondary principles, identifying specific basic goods that are intrinsically reasonable to pursue. Things that are good in themselves, not just means to other ends.
Like?
Knowledge. Knowledge is a good. It's inherently reasonable to want to know, to understand. Conversely, falsehood and ignorance are evils we naturally seek to overcome. You don't need to justify why you want to know something true. The desire to know is itself a fundamental reason for action.
That makes sense. But then there's a third principle you mentioned, the one that really sets natural law apart from, say, utilitarianism.
Ah, yes. This one's crucial and often controversial today. The principle is, you may never intentionally do evil, even if you foresee or hope that good might come of it.
Never choose evil as your means.
Never. This establishes absolute moral prohibitions. Certain actions are intrinsically unreasonable, intrinsically evil, and therefore off limits, regardless of the potential consequences.
Can you give an example? Because consequences matter, right?
They do matter, but they don't justify choosing an evil act itself. Think about the difference between wartime bombing scenarios.
Okay.
Scenario A. You target a crucial enemy munitions factory, with high probability that tragically some civilians living nearby might be killed as an unintended side effect, collateral damage.
Right. A terrible outcome, but not the goal.
Exactly. The intention, the chosen act, is directed at a legitimate military target. The civilian deaths are foreseen, but not intended. Now, scenario B. You intentionally target a civilian neighborhood with bombs precisely in order to kill non-combatants and terrorize the enemy population into surrendering.
The goal might be the same, ending the war, defeating tyranny, but the action is totally different.
Fundamentally different in moral terms. In scenario B, the chosen means is murder, the intentional killing of innocents. Natural law says that choosing murder is always intrinsically unreasonable and evil. You cannot choose that evil, even for a good end like peace.
So the ends don't justify the means if the means themselves are intrinsically wrong.
Precisely. That principle is the ultimate backstop for human dignity. It says some actions are just wrong, period, no matter how beneficial the predicted outcome.
Okay, so these principles are derived from reason. Right. How does the tradition argue they're universally knowable? Why natural in that sense?
They're considered natural because they pertain to human nature itself, specifically our rational nature. Since all humans share this capacity for reason, these basic principles are, in principle, knowable by anyone.
Through reflection.
Through reflection on our own inclinations and experiences of what constitutes a reason for acting. The ultimate point of these principles is to guide us toward human flourishing, living a good life as human beings. And flourishing happens when we freely choose things that are intrinsically good, things that fulfill us as rational creatures.
You mentioned knowledge as the self-evident good. Can you give another example? Something that doesn't need justification beyond itself.
Sure. Let's take friendship or sociability. Why do people seek companionship, build communities? You could list instrumental reasons: safety, economic benefit, but underlying it all is the basic good of relating to others, of community itself. It's intrinsically fulfilling for social creatures like us. Or think about life and health. We act to preserve our lives and health. Why? Well, ultimately because life itself is the condition for pursuing any other good. It's a fundamental, self-evident reason for action. Contemporary natural law thinkers often list several: life, knowledge, skillful performance or play, aesthetic experience, friendship, practical reasonableness itself, and religion or harmony with ultimate reality.
Religion as a basic good. How does that work?
The idea is that asking questions about ultimate meaning, about the transcendent, about whether there's a reality beyond the material world, that search itself is a fundamental human activity. Seeking harmony with whatever ultimate source of meaning there might be is an intrinsically reasonable pursuit, whether you end up theistic, agnostic, or atheistic. The questioning and seeking is the basic good.
I see. It's about the rational drive to understand ultimate things.
Exactly. And the choice to pursue that understanding requires no further justification. It's good in itself.
This brings us back to the core of moral action then. It's not just about knowing the good, but choosing it. Natural law insists that truly human actions have to be free.
Absolutely central. You need both reason to identify the goods and the principles and free choice to actually commit yourself to a course of action.
Free choice meaning?
Meaning the capacity of the will to intelligently select one option among several possibilities after deliberation. It's not just being pushed around by emotions or external forces. If our actions were predetermined, if free choice was just an illusion,
then morality wouldn't really make sense. You can't praise or blame someone for something they couldn't help doing.
Exactly. Moral responsibility evaporates. Natural law fundamentally rejects that kind of determinism. It insists that we do make real choices, and those choices have consequences.
And not just external consequences, right? There's this distinction, transitive and intransitive effects.
Yes. Crucial distinction. The transitive effect is what our action does to the outside world. I build a chair, the wood changes shape, there's a chair where there wasn't one before. Simple enough. But the intransitive effect is what the choice does to me, the chooser. By choosing to act honestly or dishonestly, patiently or impatiently, courageously or cowardly, I am shaping my own character.
So every choice is, in a way, an act of self-creation.
That's a perfect way to put it. Every free choice contributes to building habits. Good habits or virtues. They make it easier to choose the good in the future. Bad habits or vices, they incline us toward evil and make choosing the good harder.
Which is why cultivating virtue, prudence, justice, courage, temperance is so important in this tradition. It's about building the capacity for consistent good choices.
Precisely. Virtues aren't just nice traits. They are the operational skills needed to live a flourishing life according to reason. They enable freedom, in a sense.
Okay, that internal dimension, choice, shaping character provides a strong foundation. Now, let's bridge that to the external world in Section 2. How does this translate into rights, justice, and claims against the state? You said earlier, modern thinking often sees rights as state-given.
Yeah, as grants or permissions from the government. Natural law completely flips that.
How so?
It insists that rights are grounded in this objective moral order, in what's due to human beings based on their nature. The state doesn't invent them. Its job is to recognize and protect them. This moral foundation exists before the state and limits the state.
You mentioned the term iritus and how its meaning shifted. Can we unpack that a bit?
Sure. For Aristotle and Aquinas, iritus primarily meant the just thing, or what is due in a particular relationship or situation. It was objective. If I owe you $10, the iritus is the $10 itself, the object of the just relationship.
So focused on the action or the thing owed.
Right. But later thinkers, especially the Spanish scholastics in the 16th century, like Francisco Suarez, started to shift the focus.
Suarez, okay. What did he do?
He defined irecus not just as the objective thing owed, but also as a moral power or faculty that a person has. A power over their own property, or a power to claim what is due to them.
Ah, so that sounds much more like our modern idea of a right, something an individual possesses.
Exactly. It's a crucial step towards the modern subjective understanding of rights as inherent claims or entitlements held by individuals.
And this wasn't just an academic exercise, was it? There was a political context.
Oh, very much so. Suarez and others were writing directly against the theory of the divine right of kings,
Which held that the king's power came directly from God and was absolute.
pretty much. The king was answerable only to God, not to the people or any earthly law. Suarez countered this by arguing that individuals possess these natural rights, these moral powers inherent in their humanity, independent of the king's decree.
So rights became a bulwark against arbitrary royal power.
Precisely. They established that certain freedoms and protections were owed to people simply because they were people, grounded in natural reason, and the monarch had a duty to respect them. Hugo Grotius, a bit later, reinforced this, defining a right Harslius as a moral quality, enabling a person to have or do something justly like the right to self-defense, which doesn't depend on state permission.
So the bottom line is, natural rights, life, liberty, property, etc., get their force because they reflect the requirements of natural law, of reason itself.
That's the core connection. Without that grounding in objective morality, rights risk becoming just, demands, assertions of will, as one source put it.
If they're just based on whoever shouts loudest or holds the most power,
Then they're not really stable, are they? They can be redefined or abolished by the state whenever it's convenient. They lose that unalienable quality the American founders talked about.
that term unalienable really captures it. It can't be taken away because it wasn't granted by human power in the first place.
Exactly. And thinkers like Jacques Maritain in the 20th century really hammered this home. If you want to take rights seriously, you have to take natural law seriously. Otherwise, rights float free from their moral anchor.
Let's revisit the religious liberty example. How does that right flow from the basic goods we talked about?
Okay, so we identified knowledge of truth, especially about ultimate reality, as a basic self-evident good. It's reasonable to seek understanding about the biggest questions, God, meaning justice.
Right. The drive to know.
Well, that search inherently requires freedom. You can't force someone to genuinely believe something or to arrive at truth.
Coercion short-circuits the whole process.
Completely. If someone conforms externally out of fear or to gain favor, they haven't made an authentic internal choice for what they perceive as true. The act of seeking truth, which is the good here, has been corrupted.
So the right to religious freedom is essentially protecting the space needed to pursue that basic good authentically.
Precisely. It's a legal shield ensuring that the state doesn't interfere with that internal conscientious search for ultimate truth.
And what does recognizing such a right imply about the state itself?
It immediately implies a limited state. A government that acknowledges a right to religious freedom is implicitly saying there are areas of human life conscience, the search for ultimate truth, where we, the state, are incompetent and lack authority. It's a fundamental limit on state power derived from the nature of the good being protected.
Okay, that leads us nicely into justice. Natural law sees justice not just as fair laws, but as a personal virtue.
Yes, following Aristotle, justice is the virtue, the ingrained habit, of consistently willing to give others what is due to them.
What they are owed. And this virtue is directed towards the common good. We need to be careful with that term, right?
Very careful. Common good in this tradition does not mean collectivism or the state owning everything or the individual being subordinate to the group.
So what does it mean in a political context?
It refers to the set of conditions within society that help individuals and groups to flourish, to pursue the basic goods for themselves. It's instrumental. Things like peace and public order, a fair legal system, protection of rights, basic infrastructure, defense against external threats. The state's job in promoting the common good is to establish and maintain these conditions.
So the state facilitates flourishing, it doesn't dictate it or absorb it.
Exactly. The common good serves the good of individuals. Individuals don't exist merely to serve the state's version of the common good. Within this, you have different kinds of justice that address different relationships.
Like distributive justice.
Right. That concerns the relationship between the community, usually represented by the state, and its individual members. It's about the fair distribution of common resources, benefits, and burdens. Think about how taxes are levied or how public funds are allocated. Fairness here might be based on criteria like need, merit, or function.
Okay. Then there's commutative justice.
That governs the relationships between individuals or groups. It's about fairness in exchanges, contracts, and rectifying wrongs. If I buy something from you, commutative justice demands I pay the agreed price and you deliver the goods. If I damage your property, commutative justice demands I compensate you fairly. It's justice in one-to-one dealings.
Straightforward enough. What about social justice? That term gets used a lot, sometimes vaguely. How does it fit here?
It's a somewhat later concept, really gaining prominence in the 19th and 20th centuries, particularly in Catholic social teaching. It was partly developed to recover the classical idea of general justice, the idea that everyone has a responsibility to contribute to the overall good of the community.
So it's broader than just fair exchange or distribution.
Yes. Social justice, as articulated by thinkers like Pope Pius XI, is the virtue that directs individuals to use their freedom and resources to actively promote the common good, those conditions necessary for everyone's flourishing. It emphasizes that we all have a positive duty to build a just society, not just avoid injustice in our personal dealings. It calls for free choices aimed at the common good.
This focus on justice and the common good as defining the purpose of law leads us straight into Section 3, how natural law inherently calls for limited government and the rule of law.
Right, because if law has a specific purpose grounded in reason, it can't just be anything the ruler wants.
Let's break down that definition of law from Aquinas again. An ordinance of reason for the common good, made by him who has care of the community and promulgated. Each part seems like a constraint.
It absolutely is. First, ordinance of reason. The law can't be arbitrary or irrational. It has to align with natural law principles.
Second, for the common good. It must aim to benefit the community as a whole, not just the ruler or some special interest group.
Third, made by him who has care of the community. It has to come from legitimate authority responsible for the community's well-being.
And fourth, promulgated. It has to be made known to the people who are expected to follow it. No secret laws.
Exactly. So even seemingly mundane laws like traffic regulations have to meet these criteria. They're based on reason, protecting life and health, serve the common good, preventing chaos and injury, are made by legitimate authority, the legislature or transport authority, and are publicly known. Speed limits are posted, rules are published.
And if law must conform to reason, to natural law, then the state itself isn't above morality. Government officials are bound by the same basic moral rules as everyone else.
That's the crucial implication. The state cannot command actions that are intrinsically evil according to natural law. It can't legitimately order torture or the killing of innocents or demand perjury.
Even if it passes a law saying it can.
Even then, an unjust law, one that violates natural law in a fundamental way, lacks true binding force in conscience. As the tradition puts it, lex injusta non est lex in unjust law is not truly law. That's the ultimate moral check on state power.
Now, does this mean the state should try to legislate all morality? Should it ban every sin? That's a common worry about natural law thinking.
It's a common misunderstanding, but the natural law tradition itself argues against that kind of hyper-moralistic state.
Why? If something is morally wrong, shouldn't the state prohibit it?
The state's primary responsibility, according to Aquinas and others, is focused on the political common good specifically, maintaining justice and peace, what he called the temporal tranquility of the state. Its job isn't to make everyone perfectly virtuous in all aspects of their private lives.
So it focuses on public order.
Primarily. It prohibits actions that directly harm others or undermine the basic fabric of society, things like murder, theft, assault, fraud. But many private vices, while morally wrong, might not directly threaten public peace or justice. Think of private gluttony or laziness or even certain kinds of lying that don't involve fraud or perjury.
The state generally stays out of those.
Generally, yes. Trying to legislate every private moral failing would be impractical, intrusive, and likely counterproductive. It could lead to resentment and instability. As Aquinas noted, human law aims to lead people to virtue gradually, starting with prohibiting the most serious evils that disrupt social life. It can't and shouldn't try to enforce the entirety of the moral law.
That's a really important clarification. It keeps the state focused on its proper, limited sphere, which brings us to another key limiting principle, subsidiarity. What's that about?
Subsidiarity comes from the Latin subsidium, meaning help or assistance. It's the principle that higher levels of organization, especially the state, should not take over functions that can be performed effectively by lower levels, individuals, families, local communities, voluntary associations, businesses.
So don't centralize things unnecessarily.
Exactly. The role of the higher order is to assist subsidium, the lower orders when necessary, to help them do their own jobs, not to absorb their functions.
Why is this so vital for freedom? Isn't central control sometimes more efficient?
It might seem more efficient in the short term, maybe, but efficiency isn't the highest value. Human flourishing requires personal responsibility, initiative, free choice. We grow and develop by doing things for ourselves, by solving our own problems within our families and communities.
And if the state steps in and does everything,
it undermines that responsibility. It can create dependency, stifle initiative, and ultimately erode freedom. People become passive recipients rather than active agents. That's why even necessary state interventions, according to thinkers like John Paul II, should be targeted and ideally temporary, as brief as possible, to avoid permanently taking over functions that belong closer to the individual.
So subsidiarity protects the space for civil society to function freely.
Precisely. It's a direct consequence of seeing the state's role as serving the common good, which in turn serves individual flourishing that largely happens outside the direct control of the state.
All these limits, law based on reason, focus on public justice, subsidiarity, they all point towards the rule of law. How does natural law understand that concept?
The rule of law in this tradition isn't just about having laws and procedures. It's fundamentally about the rule of reason, not the rule of men. It's the institutional embodiment of the idea that government should be constrained by rational, knowable principles, not by the arbitrary will of those in power.
Arbitrary power being inherently unjust.
Yes. Because it's not based on reason aimed at the common good. The legal philosopher Lon Fuller, though not strictly a traditional natural lawyer, captured this brilliantly with his idea of the inner morality of law.
The inner morality. What did he mean by that?
He argued that for something to even count as law in a meaningful sense, it has to meet certain procedural requirements that stem from the nature of law as a rational enterprise guiding human conduct.
What kind of requirements?
He listed 8. Laws must be general, apply to classes of people, not specific individuals. They must be publicly promulgated, made known. They must be prospective, apply to future actions, not past ones. They must be clear and understandable. They must be consistent, not internally contradictory. They must be relatively stable, not changing constantly. They must not demand the impossible. And finally, there must be congruence between the rules as announced and their actual administration.
So, if a supposed law fails badly on these points, like secret laws or constantly changing rules or retroactive punishments, it's not just bad law. It's arguably not really law at all.
That's Fuller's point, and it resonates strongly with the natural law tradition. Such decrees lack the fundamental rationality required to guide free and responsible citizens. They represent a failure of the rule of reason, devolving into the arbitrary rule of men. Okay, moving into section 4, let's apply this framework to the economic sphere: property, markets, economic liberty. This is an area where, perhaps surprisingly to some, natural law thinkers, especially those later scholastics, were way ahead of the curve.
Right. You mentioned there's a central paradox regarding property. Natural law says the earth and its resources are fundamentally for the common use of all humanity.
That's the starting point, derived from reason reflecting on human needs. Material goods exist to sustain human life and flourishing for everyone.
Yet the tradition strongly defends private ownership. How does that square? Why not common ownership if the goal is common use?
Aquinas tackled this head-on, drawing from Aristotle. He argued that while the destination of goods is common, the most rational and effective means of managing them for that purpose is typically through private ownership, or at least private stewardship.
And he gave specific reasons.
He gave 3 main practical arguments. First, people tend to take better care of things that are their own responsibility, compared to things held in common where responsibility is diffused.
The tragedy of the commons idea, basically.
A precursor to it, yes. Second, private ownership helps order human affairs and avoids confusion. If everyone knows what they're responsible for managing, things run more smoothly.
Makes sense.
And third, it generally promotes peace. Clearly defined ownership reduces disputes over who gets to use what. So private property, understood as the right to manage and dispose of resources, is seen as a rational institution derived from natural law principles for the sake of achieving common use more effectively.
But it's not an absolute right then, it's a means to an end.
Exactly, it's instrumental. And that's why the tradition also recognizes exceptions. If the system of private ownership, in a particular extreme case, actually prevents someone from accessing what they desperately need for survival.
The starving person example.
The classic example. If someone is in immediate, extreme, and manifest danger of death from starvation, and they take only what is necessary to survive from someone else's abundance, like an apple from a laden tree, natural law would argue this isn't theft. In that moment of dire necessity, the primordial principle of common use overrides the conventional right of private ownership.
So ownership has built-in limits based on fundamental human needs.
Yes, it's justified because it generally serves human needs well, but it can be overridden when it fundamentally fails to do so in an extreme circumstance. Some later scholastics also pointed out that common ownership can actually undermine virtues like generosity because people might rely on the community instead of exercising personal charity.
Okay, now let's get to the really surprising part for many people, the scholastics and free markets. We tend to associate market economics with Adam Smith and later thinkers.
We do, but that overlooks centuries of sophisticated economic thought within the natural law tradition, particularly at the University of Salamanca in Spain during the 15th and 16th centuries.
Salamanca. Who were these thinkers?
Figures like Francisco de Vitoria, Domingo de Soto, Martín de Azpilicueta, Luis de Molina, Juan de Mariana. They were theologians and jurists grappling with the new economic realities of their time, the influx of gold from the Americas, expanding international trade, banking, inflation.
And they applied natural law principles to these issues.
Directly. They wrote extensively on contracts, interest rates, taxation, monopolies, currency, and value theory, all from a moral perspective grounded in justice and reason.
Were they generally pro-market?
They were certainly critical of excessive state intervention that they saw as unjust or counterproductive. De Soto, for example, warned about the dangers of government debt and high taxes, arguing they oppressed the poor and violated justice.
So early critics of big government in the economy.
In many ways, yes. Juan de Mariana, writing around 1600, was incredibly forceful in condemning government-granted monopolies as unjust privileges that harm the public. And his critique of currency debasement, where the king would reduce the silver content of coins to fund his spending, was scathing.
What did he call it?
He essentially called it a hidden tax and a form of theft from the people, a violation of the king's duty to uphold justice and protect property. This was a radical assertion of individual economic rights against the sovereign.
Wow. So they saw the economy not just as a tool for the state, but as a sphere of human action governed by moral principles.
Absolutely. And they developed some key economic concepts. They understood opportunity costs, the quantity theory of money, explaining how increasing the money supply leads to inflation, and they had a very interesting theory of the just price.
What determined the just price for them? Was it based on the cost of labor, like some later theories?
Not primarily. Aquinas had already established the baseline. The just price is generally the price reached on the common market, secundum commune forum, through free exchange between willing buyers and sellers.
So the market price is usually the just price.
Yes, assuming no fraud, coercion, or monopoly. And crucially, Aquinas and the Salamancans understood that this price would naturally fluctuate based on supply and demand, copiae et inopia rerum, abundance and scarcity of things.
That sounds remarkably modern.
It is, and the later scholastics, like Molina, went even further, developing a subjective theory of value.
Subjective value.
As opposed to
value being inherent in the object itself or determined solely by the labor put into it. They argued that the value or price of a good depends primarily on its perceived utility to consumers and its rarity, as reflected in the common estimation or market consensus. Molina used terms relating to a thing's usefulness, virtuositas, scarcity, viritus, and desirability or pleasingness, complacabilitas.
So value is in the eye of the beholder, or at least in the collective judgment of the market.
Essentially, yes. This understanding that value is subjective and prices emerge from individual valuations and exchanges is a cornerstone of the Austrian school of economics and much of modern neoclassical thought. The scholastics were discussing it centuries earlier.
That's incredible. What about international trade? Did natural law have anything to say about commerce between nations? Definitely. This ties into the concept of the allis gentium, the law of nations, which they saw as derived from or closely related to natural law. Thinkers like Vittoria and Suarez addressed the rights and duties of different peoples interacting with each other.
And trade was a right.
Vittoria argued forcefully that the Spanish had a natural right to travel and trade with the native peoples of the Americas, and that the native rulers could not justly prohibit this peaceful interaction, as communication and commerce were natural aspects of human sociability intended for common benefit.
So, a right to free movement and exchange.
Yes. And Hugo Grotius, often called the father of modern international law, built heavily on this. In his famous work Mare Liberum, The Free Sea, he argued against Portuguese claims to monopoly over trade routes to the East Indies.
What was his argument?
He argued that the sea, like the air, was common to all mankind and could not be owned by any one nation. And flowing from this and natural sociability was a universal natural right to trade. He stated it very clearly. The right to engage in commerce pertains equally to all peoples. Any state hindering peaceful trade by another nation's subjects was acting unjustly, violating the law of nations derived from natural law.
So free trade wasn't just about economic efficiency for them. It was a matter of natural justice.
Exactly. Grounded in the idea of a universal human community and the common destination of goods.
Okay, we've seen how natural law provides this deep, rational foundation for individual rights, limited government, and economic liberty. Now, in Section 5, let's bring it home by looking at its role as a crucial defense against tyranny, especially in modern times.
This is where the rubber really meets the road. The 20th century provided brutal testing grounds for these ideas.
Facing totalitarianism, fascism, communism.
Exactly. And what's interesting is that these ideologies often found intellectual support, or at least acquiescence, from philosophies that rejected natural law, particularly legal positivism.
Remind us of the core idea of legal positivism again.
In its strong form, it's the view that law is simply what the recognized sovereign authority commands or posits. There's no necessary connection between law and morality. If a law is properly enacted according to the system's rules, it's valid law, regardless of whether it's just or unjust.
So law is law. End of story.
Pretty much. And you can see how that could be used to justify obeying even monstrous decrees. The starkest example, tragically, comes from the aftermath of World War II.
The Nuremberg trials.
Yes. Many high-ranking Nazi officials used a positivist defense. They argued they were just following orders, implementing laws that were legally valid within the German Third Reich at the time. Befehl ist Befehl. The law was the law.
How did the prosecution counter that?
The chief prosecutor, U.S. Supreme Court Justice Robert H. Jackson, made what was fundamentally a natural law argument, even if he didn't always use the label explicitly. He argued that the Nazi actions, genocide, aggressive war, crimes against humanity violated fundamental principles of justice that transcend any national law.
Principles that are just inherent in civilization.
Exactly. He spoke of basic principles of jurisprudence, which are assumptions of civilization. The underlying premise was that there's a higher law, a moral law accessible to reason, that limits what states can legitimately do. Laws commanding mass murder or stripping entire groups of their humanity are so fundamentally unjust that they lack the character of true law. Lex injusta non est lex.
That's an incredibly powerful claim. It essentially put the Nazi state itself on trial against a standard of universal justice.
It did. Without recourse to some form of natural law or universal moral principles, it's actually very difficult to legally condemn actions that were, however horrific, technically legal under the positive law of the regime that committed them. Nuremberg rests, implicitly or explicitly, on the idea that state sovereignty is not absolute. It's limited by fundamental moral norms.
So, natural law provides that ultimate backstop against state-sanctioned evil. What about its relevance today, in less extreme situations, in liberal democracies? Does it still serve a purpose against maybe more subtle threats?
I think it absolutely does, particularly as a defense against the erosion of rights through moral relativism or subjectivism.
How so?
Well, if there's no objective moral truth underlying rights, if rights are just seen as strong preferences or products of political negotiation or court decisions, they become quite fragile.
You get what Marianne Glendon called rights talk.
Exactly. Where a political debate becomes just a clash of competing, absolute-sounding rights claims, disconnected from any shared understanding of the common good or underlying moral responsibilities. Thinkers like Ronald Dworkin, while influential, argued for identifying rights without employing any particular conception of the good life.
So, rights detached from any idea of objective good.
Right, but the danger is, If rights aren't grounded in something more solid than current consensus or judicial preference, what happens when the consensus shifts or the judges change their minds?
They become insecure, malleable.
They risk becoming merely state-granted privileges again, easily redefined or restricted when they become inconvenient. The unalienable quality depends on their being grounded in something deeper than politics in our nature and the moral truths knowable through reason.
There was that argument from Richard Rorty you mentioned that philosophical skepticism denying objective truth is actually good for democracy because it prevents fanaticism.
Yes, the idea that if everyone accepts that morality is just opinion, we'll all be more tolerant.
But does that hold up? What's the natural law counter-argument?
The counter-argument is that if there really is no truth, only opinion, then public life ceases to be about a shared search for justice and the common good through reasoned debate.
What does it become?
It risks becoming purely a contest of power. Whose opinion will prevail? Whoever can muster the most votes, the most influence, the most force. If my deeply felt conviction about justice is just my opinion, and the tyrant's deeply felt conviction about his right to rule is just his opinion, on what objective basis can I condemn his actions? My outrage becomes just another subjective feeling.
So rejecting objective moral truth ultimately undermines the very basis for reasoned political argument and resistance to injustice.
That's the deep concern. Natural law insists that our commitment to liberty and justice needs a firmer foundation than shifting opinions. It provides principles grounded in reason, knowable in principle by all, independent of passing fashions or powerful interests that can serve as a stable anchor.
Because if the state is seen as the creator of rights,
then the state can also be the destroyer of rights. It transforms unalienable rights into conditional permissions. Natural law stands as a constant reminder that legitimate authority is derived from adherence to reason and justice, not the other way around. It remains, as one author put it, an enormous potential to serve as a powerful ballast for the free society, constantly reminding us why liberty matters and why it requires our eternal vigilance.
Wow. That really brings together centuries of thought into a powerful, coherent picture. We've journeyed from Plato and Aristotle through Aquinas' synthesis, the economic insights of the scholastics, right up to the challenges of the 20th century and today. It underscores natural law, not just as history, but as this living, rational framework.
A framework for understanding limited government, the basis of private property and economic freedom, and the ultimate source of our most fundamental human rights, life, liberty, the pursuit of flourishing.
So let's try to boil down the key takeaways for listeners. What are the absolute must-remember points from this deep dive?
Okay, I'd say three main things. First, rights are discovered, not created. They're moral realities rooted in our shared human nature and reason, which legitimate governments must recognize and protect, not invent or arbitrarily redefine.
Right. They precede the state.
Second, legitimate law is an ordinance of reason for the common good. Human laws must align with fundamental moral principles, natural law, and genuinely aim to foster the conditions where individuals can flourish. Law that is purely arbitrary or serves only private interests isn't truly law.
Reason and common good are the benchmarks.
And third, there are exceptionless moral norms. Certain actions are intrinsically wrong, like intentionally killing the innocent, and can never be justified, even by good intentions or state decree. These moral absolutes provide a non-negotiable floor for justice and human dignity.
Discoverable rights, law based on reason for the common good, and absolute moral limits. That's a powerful foundation.
It is. And it stands in pretty stark contrast to views that see law as just power or rights as just preferences.
Which leads us to our final provocative thought for you, the listener, to mull over. Building on everything we've discussed, especially that challenge of skepticism, here it is. If we let go of natural law's commitment to universal moral truth, if we truly embrace the idea that all morality is just subjective opinion or cultural construct, how then can we objectively ground the profound sense of outrage we feel and arguably should feel when basic freedoms and justice are crushed, whether here or abroad? What really justifies that outrage if not a shared standard of reason and human dignity that transcends mere opinion?
Something to think about.
Well, that's about all the time we have. You've been listening to the deep dive from Wake Up and Smell the Freedom, where ideas percolate. Thanks for joining us as we continue to explore the ideas that shaped liberty and continue to shape us today. Remember, the pursuit of liberty begins with understanding, and understanding begins with asking the right questions. Until next time.